MidPenn Legal Services is a nonprofit public interest law firm. We provide free legal services in civil cases to residents in 18 counties in central Pennsylvania. Our clients are primarily individuals who are living at or near the poverty threshold and survivors of domestic violence. You can find out more about our work by visiting our website, www.midpenn.org, or visiting any of our social media platforms. Our social media handle is Legal MidPenn. This session has been made possible by a grant from the Pennsylvania Interest on Lawyer Trust Account Board and is being recorded. It will be available on MidPenn's YouTube channel, and attendees are in listen-only mode. If you have a question, please enter it in the chat box. After the session, if you have a question, feel free to message us on Facebook or email us at development@midpenn.org.
Hello, everyone, and thank you for joining us again for part 2 for this interesting discussion. Daniel Handley, who is with us today, will be leading the discussion, and he will give us a really good tips on how to choose a good power of attorney. Daniel Handley was raised in Delaware. He served for 2 years as a missionary for the Church of Jesus Christ of Latter-day Saints in Phoenix, Arizona, where he worked closely with community leaders to serve low-income populations. After graduating from Brigham Young University with a BA in history, he earned his law degree from Penn State Dickinson School of Law. During law school, he volunteered with Youth Legal Services, again serving low-income populations. He also interned at an elder law firm where he focused on preparing powers of attorney and helping victims of elder financial abuse. And with that being said, we will turn it over to Daniel to kick off our discussion.
Thank you, and good afternoon, everyone. Welcome to part 2. Part 1 was where we took a deeper dive into powers of attorney, what they are, what they aren't, basics on how to set one up, what to include, things like that. So part 2, we are going to talk about the powers and duties of a power of attorney agent and how to choose a good agent. Before we really begin, the disclaimer, this is an informational session, not legal advice. So if you do have those questions, and you can type them in the chat and we'll try to answer them, but today is going to be informational. I am the Project Safe attorney at MidPenn, and Project Safe stands for Safeguarding Vulnerable Populations Against Financial Exploitation. So the primary goal of Project Safe is to conduct education and outreach about powers of attorney across MidPenn's service area, with a focus on targeting vulnerable populations such as the elderly and disabled. Project Safe can also provide legal representation for creation and revocation of powers of attorneys to qualified individuals, as well as assisting individuals who may have been financially exploited. As a sort of a recap, but just a baseline understanding, the power of attorney is a legal document where someone appoints a substitute decision maker to handle financial decisions on their behalf. And it generally avoids the need for a court-appointed guardian and to avoid those expenses of a guardianship. Key terms: the principal is the person who grants the authority. The agent is the person who is appointed to act on behalf of the principal. I hear a lot of people say, I have a power of attorney, when they are referring to the person that they have named as their agent. So it's important to, important to say, I have an agent under or through a power of attorney, which is the document. And then another key basic principle of powers of attorney is the principal must be of sound mind or have capacity to sign a power of attorney. I focus on trying to have people do these as soon as possible, so that if you find that you need it and you haven't prepared, then it might be too late to get one set up. The attorney determines if a person has capacity, and so the principal needs to understand the powers and authorities that they are granting to an agent. And this is important because we're going to talk about all sorts of things, all sorts of powers and authorities that you can grant an agent. So the principal needs to understand those principles. Two requirements of a power of attorney is that at the beginning there has to be a notice form, which informs the principal and provides a general outline of the types of things an agent can handle. And the principal signs this, stating that they understand the purpose of this document and the great weight that it carries. The acknowledgement form is at the end of the power of attorney, and it is where the agent signs and they pledge that they are going to act responsibly, that they're going to do the things that the principal wants them to do in an appropriate way. And so from the power of attorney statute, the section on duties, the agent has a duty to act in accordance with the principal's reasonable expectations, or in the principal's best interest. The agent has to act in good faith, and they can only act within the scope of authority granted them. This language is really important because it is the language of the acknowledgement. The agent signs this acknowledgement. They pledge that they will do these things. They are pledging that they will obey the law. So this carries a lot of responsibility. As a principal, you need to pick someone to be your agent that you trust. And trust is going to be a key component throughout today's presentation, and we're going to come back to it very often. A person who is named to manage someone's money or property is a fiduciary. A fiduciary must manage a principal's money and property for the principal's benefit. Financial exploitation can occur when a fiduciary abuses that power. The person you appoint as your fiduciary should be trustworthy and honest. The fiduciary has 4 basic duties: to act only in the principal's interest. They have to manage money and property carefully. They have to keep money and property separate from the principal. There are some exceptions. If spouses are married, then one is named as an agent, then you don't have to keep the money separate. If the money was commingled before the naming of the agent, then it doesn't have to be separate at that point, but it's always a good practice to keep it as much as you can, keep it separate, and then to keep really good records. Keeping records of every debit, every credit, every transaction. Because if the court asks for an accounting, or if there's a baked-in provision to the power of attorney that requires an accounting to someone else, the agent wants to make sure that they are dotting every I, crossing every T, and that everything is above the table, and that they can prove that they are acting only in the principal's best interest. There are a few risks with having and setting up a power of attorney. It gives someone else, the principal's agent, a great deal of authority over their finances. Now, usually it's without regular oversight. This can be set up as a provision to require regular oversight for the agent. And Abuse can take many forms, and part 3 of our series will cover all about abuse and exploitation. But as a kind of a teaser, your agent could pressure you to grant more authority than you want to grant them. They can also spend your money on him or herself rather than for your benefit. And then your agent might do things that you didn't authorize them to do. They might go outside the scope of their authority. They might make gifts or change beneficiaries. And so these are some of the risks that we try to prevent. Which comes to our safeguards. We want to be a trusting people. We want to trust. That's, relationships are built on trust, but we want to make sure that people are worthy of our trust. When selecting an agent, you want to appoint someone that you trust, and make sure that they know your wishes and preferences. Like I said before, you can require in your power of attorney that your agent regularly report to another person on all the financial transactions that they're making on your behalf, as a built-in safeguard. Key points are: you want to avoid appointing anyone who mismanages money. If they're not good at managing their own money, they might not be good at managing someone else's money. You also don't want to appoint someone who has problems with substance abuse or gambling. You want to tell your friends and family members, financial advisors, about your power of attorney and about your agent, so that they can look out for you as the principal. You don't want the first time the bank to meet your agent is when they're trying to act for you. You want to make sure that they have a copy of your document, they know who your agent is, so that everything is seamless. You want to also, when you visit your financial institution, you want to make sure that you fill out any forms that they need to make sure the process goes smoothly. A POA is valid in Pennsylvania. It has to be accepted by a financial institution, but they can drag their feet sometimes. And so you want to make sure that you fill out their forms as well. Something to remember is that power of attorney designations are not written in stone. You can change, cancel, revoke them at any time, as long as the principal has capacity. If a principal decides that an agent isn't the best person or is no longer the best person to handle their finances, then you can make changes or revoke the agent's authority. An important point is to notify your agent that they no longer have authority, and notify the financial institutions, because an agent can still act for you if the agent doesn't have notice. And so if they do try to come to your bank and try to do something for you, the bank is on notice that that agent no longer has authority. A principal wants to avoid appointing hired caregivers or other paid helpers as an agent under a power of attorney to help prevent conflicts of interest. You also want to avoid people who want to do this. It's kind of really complex, and it's a great responsibility. So you want to avoid people who are willing to do this and are eager to do it and want to be your best friend, so that they may have other motives than serving for your best benefit. Other duties of an agent, we've talked about being loyal and keeping funds separate, keeping good records. They also need to cooperate with other agents that you have, such as a healthcare agent under a healthcare power of attorney, and they need to work together and share information. And then as far as they know the principal's estate plan, they need to preserve the money so that it follows the estate plan. If they don't know your estate plan, then the agent can make financial decisions that may sort of ruin the estate plan or ruin what amounts go to which people in as your beneficiaries. I think it's helpful to understand what types of powers a principal can grant an agent. A person who's thinking about making a power of attorney may think, what am I allowed to do? Like, what am I allowed to have my agent do? What authority can I grant them? So a principal, if we look at the statute, it gives us lots of great ideas and things that a principal should think about. And then when they meet with their attorney, the attorney will focus on which powers and authorities this particular principal needs to grant their agent. And so this slide talks about granting your agent authority to do things with trusts and estates. This slide has to do with real and personal property, stocks, bonds and securities, commodities, options, banking and financial, borrowing money, safe deposit boxes. This slide has to do with insurance, annuities, retirement plans, claims, litigation, government benefits, tax matters, operating a business. So some may be applicable to some principles and others may not be applicable. If I don't have a business and I become incapacitated, I may not want my agent to start a business and have to operate that while I'm incapacitated. So if it's not applicable, we don't want to grant authorities that principals don't need.
Daniel, we have a question.
Yes.
Do you believe that most caregiver agencies have internal policies that forbid a caregiver from being an agent?
I have heard that. There are care agencies that will not let their workers act as like witnesses to documents. But if you are hiring someone, you know, say a neighbor to act as a caregiver, you wouldn't, you know, if they're not for an agency, say it's just someone that has their kind of their own business, then I would avoid appointing someone that I have come in and take care of me. I would avoid appointing them as my agent. Agencies would probably have a prohibition on that, but there are people who are self-employed, and I would avoid doing it that way. These are kind of the main considerations or factors to consider when choosing an agent for a power of attorney. And the number one thing that we've talked about is someone that's earned trust. The best agent might not be the child that you live with or that lives next door, but has an addiction or trouble with the law. The best agent might not be your most trustworthy child, but lives across the country. They, depending on what needs to be done, they might not be able to handle everything if they live far away geographically. Usually you want to have someone that you know very well, and it's helpful to have someone that shares your values, that also shares your convictions. They're more likely to follow your instructions and wishes if they also hold those wishes and convictions themselves. You want to appoint someone who is responsible under stress. We talked about someone who's good with their money, possibly having experience managing someone else's affairs and their finances. And then you want to have someone who understands the legal responsibilities of acting as an agent, someone who's going to take it seriously, and someone who's going to comply with the law and make sure everything is above board. something that we can start with when trying to choose prospective agents is running a criminal background check. Typing their name in the Pennsylvania judicial system is a nice way of checking for red flags. And we can do this for different states that the agent may have worked or lived. And we're looking for red flags, like I said, things that may raise a red flag are maybe not speeding tickets, but things like forgery, embezzlement, fraud, like tax fraud, mail fraud, wire fraud, credit card fraud, insurance fraud, identity theft, passing bad checks, right? All these different things. These are crimes that contain elements of deceit, lying, misrepresentation, producing false documents, making false or misleading statements, or impersonating others in order to make a personal gain. So if someone has done these things, then they may do them again. And we want to avoid putting a principal in a situation where they can be taken advantage of. A person may, excuse me, a person may appoint more than one person to be their agent. And we'll talk about on the next slide successor agents, but one way of going about it is having co-agents. And this is where multiple agents have the authority at the same time. And if you do it this way, you want to be specific in the document whether the agents can act independently of each other, or if they have to all be in agreement or all be at the same place to sign things, because the default is they have to act jointly. And you can set up things like decisions have to be unanimous and majority rule, and everyone knows that everyone gets along all the time, right? And making financial decisions regarding mom or dad. So you want to be specific about how you want to go about that. Co-agents have the duty to coordinate with each other and share information. And that coordination and information sharing may not always happen. And so this is the messier of the two. Some principals may not want to offend their children or grandchildren and think the best idea is just to name all of their children or grandchildren as agents. The better idea, I think, is having successor agents, where I could name all of my children or grandchildren as agents, but that the first person named in my document is the only person granted authority at that time. And then if that original agent becomes unwilling or unable to serve as an agent, then it would go in the order I named. And so the second agent is the only person with the authority at that time. And they can get input from the other agents, right? This whole process is supported decision-making. And so we make decisions based on information shared with us from institutions, financial institutions, medical institutions. And so the agent has the final say, but they can work together. And then if the second agent becomes unwilling or unable to serve as the agent, then the authority would kick in for the third person named. And then that third person would have the sole authority at that time. So this, I think it's helpful to, if I were making a document, if I was a principal, it's helpful to know what my agent should be doing and what they should not be doing, so that I can keep an eye out on myself while I still have capacity, and then so that I can make sure that so that my agent's equipped with all the right tools, right? This is a big deal. This is a great responsibility. So as a principal, I would want to make sure that my agent has all the right tools to be successful in taking care of stepping in my shoes legally when I need them to. So I want to make sure that my agent reads the power of attorney first, right? Maybe first I might ask them whether they're okay doing it. Then second, I'll have them, once they're appointed as the agent, I'll have them read the power of attorney. And because not all powers of attorney are the same, right? We have general powers of attorney that can grant lots of different powers, full powers to do anything that the principal could do regarding their financial matters. And then there are other powers of attorney that are limited to very specific actions. And you can only do the things that your document authorizes you to do. So a power of attorney is not just a free pass, a license to do whatever you want to do as the agent. You have to act in the principal's best interests. The agent needs to sign the power of attorney. The agent does not have authority until they sign the document. And so when you have successor agents, the agents don't sign the document all at the same time. When say the original agent is no longer able to serve, then the second agent signs, and that's what makes it give effect to their authority. You want to make several copies of the power of attorney and give them to all of the financial institutions like banks, brokerage houses, mutual funds, state retirement, insurance companies, and make sure that they know what is contained in the power of attorney so that they can keep an eye out on the principal. And because your agent could come in, and even if they're not a bad actor, they could come in and try to do something that they're not authorized to do, and the bank might be able to catch it if they know what's in your power of attorney. An agent needs to make a complete list. They need to inventory all of the principal's assets and income sources. They need to do this so that they know what they're responsible for. They need to know what's available for paying bills and things like that. So if they have lots of things to manage, then they can also hire people to help. They need to keep a record of everything so that they can make sure that real estate and motor vehicle, property is insured. So having a list of everything is important. We talked about having separation, the principal's assets from the agent's assets. So an agent should not commingle assets, and you don't want to have the agent's monies, like their income, being deposited into the principal's bank accounts. Keeping good records is one of the really important parts, so that there is a good record. There's the accounting, the accountability. So if the court, I may have a good agent that is a good actor, but if they're not keeping good records, then the court could punish them and have them removed, and there could be other sanctions. The agent is not allowed to borrow and use the principal's assets for themselves. Gifts are a really hot topic. The principal may have wanted to make gifts to their children and their grandchildren, but the agent should not use the principal's money to make gifts to the agent's children or grandchildren. So following what the principal would have wanted. And then another point is communication is really key to avoid misunderstandings. Communicating with the principal's family members, the ones who need to know about how you are managing the principal's affairs, being transparent so that there are no hurt feelings if there doesn't need to be, and communicating with everybody that needs to know so that everyone feels okay about it, kind of thing. I talked about hiring help. If you need help with taxes, the agent is able to hire help that way and hire professionals to do things. Fees need to be reasonable. Usually family members don't really collect fees serving as agents. So being an agent is really important. And one of the key points for an agent is to follow the rules. Act in the principal's best interest, respect their wishes, and keep good records. And doing these things should keep the agent out of trouble. And so it also protects the principal. So like I said, if I'm a principal, I want my agent to know all of these points and follow them, because it protects me, above all, and I don't want my agent getting into trouble. There can be exploitation by a fiduciary. So we're revisiting these duties. Your fiduciary can be removed if he or she does not fulfill their obligations or duties. Fiduciaries can be sued and may be ordered to repay money. If elder financial exploitation is reported to the police or adult protective services, the fiduciary could be investigated. If the fiduciary is convicted of stealing the principal's assets, they can go to jail. So this is exploitation is going to be the main focus and topic of part 3 of our 3-part series. But I don't want my agent getting into trouble. So making sure you pick someone that understands these duties and is willing to accept the responsibility of only acting within the scope of authority granted them. I see there is a question.
I just shared the PowerPoint in the chat box.
Okay. And I want to thank everyone for listening today.